The Retail and Commercial Leases Act 1995, the Act, introduces certain requirements regarding the assignment of retail shop leases. Therefore, it is crucial for both the landlord and the tenant to understand their rights and obligations in the assignment process. Here are some things to consider when dealing with a lease assignment. There is no additional disclosure requirements of the landlord. The assignment request. The tenant must request an assignment in writing and provide all of the information reasonably required by the landlord. Tenant disclosure requirements. The tenant, being the assignor, must give the proposed tenant, the assignee, a copy of the original disclosure statement and details of any known changes. Time for the landlord's response. The landlord must respond to the assignor's assignment request expeditiously. If the landlord fails to give written notice to the tenant within 42 days after the request was made, the landlord will be deemed to give consent to the assignment. Assignment conditions. The landlord is only allowed to withhold its consent in limited situations. For example, where the assignee is unlikely to be able to meet financial obligations. The landlord needs to give the tenant a written statement of the grounds on which the consent is withheld. Release of future obligations. Provided that the parties have complied with their disclosure requirements adequately, the assignor will be released from ongoing obligations and liabilities under the lease after the relevant date. Costs. You should carefully check the lease clauses to see who needs to pay for the assignment costs, for example, legal and investigation costs. However, it is common practice that such costs are met by the assignor and sometimes the assignee.